Welcome and thank you for standing by. At this time, all participants will be on a listen-only mode until the question and answer session of today's conference. At that time, if you'd like to ask a question over the phone lines, please press star 1 and record your name at the prompt. This call is being recorded. If you have any objections, please disconnect at this time. I would now like to turn the call over to your host, Melissa Grosso. Thank you, ma'am. You may begin.
Great. Thanks so much, and good afternoon, good morning to everyone on the call. Thanks for joining us for today's webinar, which is the 15th in a series of 17 webinars. Today's topic is deemed exports and utilizing research universities. As the operator mentioned, I'm Melissa Grosso with the U.S. Commercial Service. I think most of you have attended multiple webinars, so you've seen this slide before. Again, I'll encourage you to connect with your local U.S. Export Assistance Center. We have them throughout the United States. We have 2 more webinars next week. Again, as you've probably heard me say in the past, we are sending out the net replays, so if you have missed any webinars in our series, feel free to listen in on the net replay. There may be a couple new folks on the line. For those who have been on the call in the past, you've heard Alfredo present on a couple different webinars in the past, but for those of you who are new to our webinar series, Alfredo is an associate with the law firm of Shipman and Goodwin. He primarily focuses, part of his practice focuses on international trade compliance and enforcement issues, so I think you'll find him an interesting speaker to listen to. And for today's webinar, we often see that even companies with a robust compliance plan are sometimes unaware of the deemed exports components of the regulations. So we're particularly pleased to welcome Alfredo today to talk about this important topic. So Alfredo, I will get your presentation queued up, and you should have control now.
Great. Thank you, Melissa, and welcome everybody. As Melissa mentioned, some of you have probably hit all 15 or 14 of the prior webinars, and trust me, you're almost done with the summer coursework here if you're going the whole series. Some, I'd imagine, who may have a narrow focus with the university specific issues may be joining us for the first time. So welcome if it is your first webinar for the summer here. As Melissa mentioned, I'm Alfredo Fernandez from Shipman and Goodwin. It's a national firm primarily based in Connecticut with offices in with DC and New York, with a national and international practice. We, in addition to general business practice, we have an international trade group of which I'm a part, and I'm happy to hit this specific topic as part of the webinar series this summer. So we'll jump right into a few hypotheticals, kind of tee up why this is an important issue. And you'll see that this is a deemed export topic with the university flavor. There's going to be some university-specific issues, but a lot of the concepts would translate beyond just the college, university, institute type setting into regular business and private sector exporters. So as one of those hypotheticals to get us started and see what we're talking about here, this is based on a real case here. You have a Chinese scientist at your U.S. company. All the visa paperwork is in order. The initial vision is to have him or her work on the commercial programs that you work on. But over time, the controls are a little lax. New people come, knowledgeable people leave to different groups, and this Chinese scientist is provided access to military technology that the company is doing. It's a very clear rule that defense articles are not to go to China or Chinese citizens without other authorization. So that kind of transfer here in the United States, counted as a deemed export, was considered an ITAR violation. It was disclosed, or discovered rather, and the DDTC, State Department, entered into an administrative settlement with a company called Microwave Engineering Corporation with these same facts in 2016. The $100,000 is a big number. It's a big penalty, but it's nowhere near some of the really, really large export penalties we've seen in the last 5 years or so. But it's a little bit of a middle of the pack, middle of the road type of example that's very realistic in terms of penalty number and how that penalty came about happening. And there are a lot of ways to prevent what happened here with the internal controls as to what a foreign employee could see. So that's a private industry type of example. Here, there's an analogous type of hypothetical scenario that happens all the time. Your university, you have a Chinese research grad student in doing some research in your U.S.-based college or university. Student visa is all in order. Again, hired and envisioned to work exclusively on non-defense engineering research. Eventually, the professor identifies the student as someone that could help on an Air Force-funded project, understands the export controls, and decides that it's okay to keep going with this particular Chinese student. This mirrors at a high level the case of University of Tennessee professor John Roth. For anyone in the university export compliance world, this is a case that's probably experienced quite the autopsy from your end, and one of the more extreme in terms of penalty and violations that we had seen in the university setting, primarily because this particular professor was found to be willfully violating the ITAR and went to jail for a number of years. Pretty controversial case anyway, but it is one to recognize, especially with this university-focused audience, how important it is for your faculty to understand the export control rules, especially those tinkering with anything potentially government or defense funded. All right, so like I said, those were a little bit of the real world things that are actually happening in the last few years. We're going to start by leveling out a little bit on the basics of export controls, on the presumption that most of you are at least somewhat familiar with the export control rules from prior seminars or your current job. We are not going to reinvent the wheel here. We're just going to touch on these briefly. The ITAR controls military items, technology, defense programs, defense services. This is under the Department of State's Directorate of Defense Trade Controls, so if you hear me say DDTC, that's what I'm talking about. Conversely, the EAR is the set of regulations that controls almost everything else. Some of the less sensitive military items that have recently moved over from the ITAR, dual-use items, those that could be civil and military, and those that are purely commercial. These are under the Bureau of Industry and Security, which is housed under the Department of Commerce. So again, if you hear me say BIS in this case, that's what I'm talking about on the Commerce Department. And I also want to point out that while not strictly always an export issue, there are OFAC issues lurking, especially in the deemed export in college and university setting, though there are different considerations in terms of how you go about evaluating your potential due diligence and potential customers and recipients of data. Given the educational nature of the college and university audience, there are some exceptions that help you avoid some OFAC licensing and application requirements that we'll briefly touch on later, but most of the presentation will focus on ITAR and EAR. So again, this is all more of an export basics recap. An export is really anything sent from the United States to a foreign destination, and that foreign destination can be the country itself with a physical, tangible export that's put in a box and shipped. But the exported item could be less tangible things like software and technology, and the foreign destination can be more than just the geographic outline of a country. It could be foreign citizens in the United States. It could be foreign citizens in a third, non-U.S. country, and it could be done in a shockingly easy amount or large amount of easy ways to export. Face-to-face conversations, telephone calls, a visit to your campus, a a business trip outside of the United States for your faculty and students, a shared screen, not unlike this WebEx we're using right now, where data is put up on the screen, electronic storage, physical storage. There's a huge spectrum of how things can be exported, and we'll get into a little bit of the definitions as to when an export is actually triggered and what has to be transferred or released to a particular foreign person or foreign country. But those are the basics, and for the purposes of the deemed export, today we're going to be focusing primarily on the non-tangible exports, but for universities and colleges, we're going to at least remind you that there can be some physical export issues as well. So in terms of the foreign person, U.S. person, who's who, how do I determine what category to put each person in? The regs define a U.S. person as U.S. citizens and U.S. permanent residents. So those are commonly known as those with the green card. U.S. or entities organized in the U.S. And branch offices of U.S. corporations. Foreign people are pretty much everyone who's not a U.S. person, a natural, living individual human who's not a U.S. citizen or permanent resident. For the university audience, it's a useful proxy that if someone has a visa, that means they are a foreign person, because if they were a citizen or lawful permanent resident, they wouldn't need the visa to begin with. Not a foolproof proxy, but a useful one. And then again, a foreign person can include companies incorporated outside of the United States. So as I mentioned, part of this title is deemed export, so we will hit the basics of what a deemed export includes. And the regs define this, and we'll have the real text on the next slide. We'll be referring to the release or transfer of technical data or technology, and technical data is the ITAR term, technology is the EAR term, and they're slightly differently defined, but in concept you get the idea. They're about the same. This is a release of that technical data to a foreign national anywhere in the world, deemed to be an export to the home country of the recipient. So foreign visitors, prospective students, hired grad students, volunteer students, faculty, visiting faculty. When you are transferring or releasing technical data to them, you need to be aware of what their home country is, and we'll get into a little bit of what home country means for them in later slides. In addition, allowing foreign nationals, wherever they are in the world, access to electronic files containing U.S. technical data, technology, whatever term is applicable to your scenario, that access is considered an export to that person's home country. And if it turns out you are initiating a deemed export, there may be a license required for you to do that, and the expectation is that you seek the appropriate export license or other authorization before that release or transfer happens. In many cases, a license is not required, in which case you'd be fine releasing certain types of data to foreign nationals because no license would have been required for that particular instance. So the deemed export is a very common occurrence. Both of those hypotheticals I gave you at the start of the presentation were deemed export issues. They were people inside the United States receiving controlled information without the appropriate export licensing. Very easy to get in trouble that way. So as of, let's see, almost a year ago, the State and Commerce departments harmonized a few key definitions. By few is inaccurate, I should say a bunch, probably almost 20 new definitions to harmonize better with each other. As part of export control reform, one of the goals was to have these two sets of regulations, the ITAR and the EAR, jive a little better with each other to make it easier on industry. I'm not going to cover all those new definitions because a lot of them would not apply and they've been covered in other webinars, but for our purposes today with deemed exports and with our audience, we're going to look at a few that are worth the deeper dives so you understand a lot of the terms like release and deemed exports and home country. We'll get into a few of these just because they will add some perspective for you as we get into a little bit of the compliance issues down the road in later slides. So here in terms of organizing the definitions, I've tried to keep an ITAR column and an EAR column where it makes sense. You'll see that a lot of the words are now almost the exact same, if not the exact same. So again, under both regs, an export means the release or otherwise transferring technology to a foreign person in the United States. And you'll notice the technical data and technology variation on the preferred terms, but in concept, the export definition is now the same for each set of regs. Again, there's added language on what it means to be deemed an export for each column here, as you'll see, and the release in the United States of technology to a foreign person deemed to be an export to the foreign person's under the EAR, most recent country of citizenship or permanent resident, and that's a distinction from the ITAR column on the left. These deemed exports are considered exports to the foreign person's countries where it's held or currently holds citizenship or holds permanent residency. So taking a moment to pause here for a second, the ITAR deemed export definition is a little more complex because you're not limited to vetting this particular foreign recipient's most recent country of citizenship or permanent residency. You have to understand the foreign recipient's citizenship now and in their prior life, the rest of their, from birth to now. Technically, if they've held citizenship in more than one country, each of those countries would be considered a recipient of that particular technology transfer. We get into very complicated compliance questions. On that note, how hard do I have to prod to the a particular person's place of birth, citizenship issues, citizenship history? There's never a great answer because you start bleeding into data privacy issues and discrimination issues, which we'll touch later. But for purposes of the ITAR, perfect compliance would include understanding all that foreign recipient's countries and making sure the particular technology transfer is in compliance with the ITAR. Of course, easier said than done, but I did want to flag that difference for you. Now, on the prior slide, I used the term release. That was part of the definition of export. The definition of release is new and fresh, or within the last year, and freshly harmonized here with each other, and it's considered a reveal when visual or other inspection by the foreign person reveals technical data. I'm sorry, getting my R words confused here. The definition of release is only really triggered when the visual or inspection reveals technology or technical data to a foreign person, and including oral and written exchanges. So if you have a visual inspection or other kind of inspection by a foreign person visiting your site, your campus, etc., but that doesn't rise to the level of revealing any technology or revealing technical data, depending on which regulations are in play here. it's not really considered a technology release. And there's some note commentary about what it means to reveal, but you can check out the real definitions at the regs, and they're cited below there for you, one for the ITAR and one for the EAR. So there is some sort of substantive trigger as to what an observation would take for it to actually be a technology release. So there are a few nice exclusions that universities and other private industry, private sector companies use. With particular focus on the EAR for the next few slides, and we'll get to ITAR afterwards, but again, this is just for the EAR. There's a section that defines and specifically carves out what is not subject to the EAR. And when something is not subject to the EAR, you don't have to worry about licensing issues because it's just outside of the jurisdiction of BIS. So that one section that you're going to want to take a look at if you haven't already is section 734.3, and I've snipped here and there where it's more appropriate, but obviously you want to take a look at the full regs. Information and software that are published, remember that term, we'll get to it, that arise or result from fundamental research, remember that term, we're going to get to that one. Released by instruction in your standard catalog courses and regular teaching labs, we'll hit that. And then that appear in open patents and published patent applications, unless they're otherwise prevented from disclosure or gagged, so to speak. The last two bullets are there for completeness because they're there in the definition, but I'm going to focus on some of those key terms in the first four bullets: published, fundamental research, released by instruction in a catalog course, and the patent application topic. And apologies for the eye test here. Try to make it as visually appealing as I could, but with that much text, it's a little hard. But it's here for your reference. You'll get a copy of the slides, and you can always check the regulatory definition for the latest and greatest in case anything is tweaked in the coming months and years. So when something is published, it is by definition not subject to the EAR. And as I mentioned, not subject to the EAR means the licensing analysis goes away. This is defined that when it's been made available to the public without restrictions upon its further dissemination. And it gives some examples, and these aren't the only examples that you can rely on. You'll see it says such as through any of the following. But 1 through 5 give you an idea of what the government is envisioning in terms of publications. These are open subscriptions that are available to anybody. If it's already in a library, electronic, or brick and mortar buildings, unlimited distribution at conferences, trade shows, exhibitions, etc. Published on a website, or submitted for a written composition with the understanding that that submission would eventually lead to a public release. Oops. Got that. And number 5 is subject to those 3 extra bullet points as well. The other key subcategory of one of those exclusions we mentioned that makes something not subject to the EAR is technology or software that arises during or results from fundamental research. Of course, as universities, you are doing fundamental research in most scenarios, so this is an important exception that you can rely on, and if you fit within the scope of this exclusion, go for it. That's what it's there for. So the keys here are whether when something gets researched and published, whether there's going to be restriction on such publication. And when you're accepting a grant or some kind of funding and you contractually agree that we cannot disclose X, Y, or Z as part of this research, or conversely, the terms and conditions of your particular funder or funding source actively say you can publish this at your own will and just give us some credit or whatever. Those are important pieces of this analysis, because if there is restriction on what you can publish, you need to be very careful before you rely on this fundamental research exclusion, or the FRE as it's commonly abbreviated in some of the literature out there. So fundamental research for purposes of the EAR, and you'll see an analogous flavor under the ITAR, is research in science, engineering, math, the results of which are ordinarily published and shared broadly within the research community, and for which the researchers have not accepted restrictions for proprietary or national security reasons. That's at sub-bullet C here. The B1, B2, and B3 give you some a little extra flavor and coloring in between the lines of when something is intended to be published without restriction. So, for example, if something gets a pre-publication review, and really the only intent of that is to make sure there's no proprietary information that's going to be disclosed to the public, et cetera, that kind of review doesn't really count as a restriction on the author. So these are also useful guideposts for you to use as you're evaluating whether your particular research is restricted or not. As I mentioned, I think earlier, there's a lot of these definitions now come with notes after that September 1st, 2016 rule change. You absolutely want to go and read all the notes, and I didn't copy all of them here because it would look like an encyclopedia on the slide if it doesn't already. But for example, there are a bunch of added flavor that aren't technically regulatory language, but you can, in good faith, use them as indicators as to whether a particular review process is fundamental research or not. So check out the notes on 734.8 in the EAR for the full story, and they'll probably answer some of the gray areas for you. I didn't pull out a full slide for one of these, but for going back a few slides, the release by instruction in a catalog course is somewhat self-explanatory. If this is, if a professor is going through the general syllabus and coursework in a regular catalog course, even with foreign students in the classroom, that is not subject to the EAR. It's considered, it's specifically carved out. So as long as the professor and the syllabus are appropriately formulated, the regular type Astronomy 101 and Telecommunications 503 type coursework should be fine to teach both in the United States or as a visiting professor externally in the a cooperative arrangement with a foreign university, as long as the university appreciates the scope of the syllabus and the content of the course as pretty standard, pretty normal catalog course material. There should not be an issue with that kind of disclosure of information. So skip back ahead to that fourth and last category we're going to explore a little deeper, that are excluded from the EAR, and that is information contained in patents. So patents are publicly available, both the U.S. Patent Office and foreign patent offices. In addition to final approved patents, patent applications are made available at some point during the application process, not right away, but at some point the application also becomes available to the public for comment and things like that. If it's in a patent that's out there and open, you're outside of the scope of the EAR, don't need to worry about the license. If it's same thing, if it's in a published patent application, you're outside of the EAR. And you'll see if this is something that's of particular interest to your faculty, you'll see a few other indicators of how the patent content may or may not keep you in the EAR. For example, though, if you have a patent-holding professor, which is a common story, the professor is always looking for the next cutting-edge improvement of a particular field in which he or she is an expert. That difference, the gap between what's covered in the patent and what may be disclosed to a foreign visiting student, a graduate student from another country, etc., there may be a gap in what is excluded from the EAR through these patent exclusions and the new information, so to speak, the latest and greatest improvement, a 1% improvement in technology that's just not covered in the original patent. You may have a little export concern there. So keep that in mind. Now, shifting gears to the ITAR here. Those previous few slides were the EAR specific exclusions, and for a lot of universities that don't do ITAR work, you're more concerned about the EAR language and not the ITAR, but on the presumption that there are some defense and DoD funded programs. For our audience today, we will hit the ITAR equivalents, and you'll start seeing that a lot of the definitions and concepts translate pretty well from one to the other. Now, the ITAR has a specific definition for technical data here that you'll see A1 through 4. But what I really want to highlight here is subsection B, where they specifically carve out information that's not considered ITAR technical data, and that includes information concerning general specific mathematical engineering principles, as you'll see in blue here, those commonly taught in schools, colleges, universities, and information in the public domain. So it's in a little different order, different organization in terms of how it introduces this type of carve-out for public domain and fundamental research, but you'll see pretty analogous concepts for keeping stuff out of the licensing world. So that public domain here includes a lot of what we've already covered, including the patents that are already just baked into the public domain, but again, on sale at bookstores, subscriptions, libraries, unlimited distribution at conferences, unlimited public release. I won't get into those details because they're the same idea that we saw for the EAR, just organized a little differently in the ITAR. But then this last major bullet here, through fundamental research in science and engineering at institutions of higher learning, the term fundamental research means basic and applied research in science and engineering, ordinarily published, ordinarily shared broadly with the scientific community, but which is, that universe is distinguished from the research that have restrictions for proprietary reasons or U.S. government access and dissemination controls. So again, similar to the research and disclosure restrictions on the EAR definition of fundamental research. All right, so again, if you're in the ITAR world, and I won't necessarily dive into every detail here because a lot of the universities may not be there, absolutely check out 120.11 in detail to make sure you are relying appropriately on the public domain exclusion. So as a little bit of a wrap-up for this piece of the presentation, employers here, in this case universities as well, really need to understand if an export license is needed before the EAR technology or the ITAR technical data is released to your non-U.S. person. And that could be, as I've mentioned a few times, an employee, whether in a technical academic or a support type role, a contractor, student, visitor, etc. Anyone who didn't meet the definition of U.S. person from the earlier slides is the non-U.S. person that deserves some attention. To have that full grasp, you need to understand the classification of your technology, and if you can't confidently rule out that your technology is not subject to the EAR or not technical data under the ITAR with those exclusions we've gone through, you need to understand what jurisdiction is in play and what the classification is. What is the USML category? That's the United States Munitions List. What is the Export Control Classification Number, or the ECCN, under the BIS regs, the Commerce Control List? If these are brand new terms for you, shoot me an email afterwards. But assuming that those are not first-time terms you're hearing, I'll keep going and only brush on these lightly. You need to also understand the destination of this particular technology transfer. Who's going to be accessing the technology, a particular electronic database, a particular email or meeting? What is, if it's an EAR item of technology, what is the most recent country of citizenship or residency? If it's a ITAR item or article of technical data, what are the current and past countries of citizenship? Because these types of information categories, will guide you as to what license may or may not be required. And lastly, you need to understand the end user. You can't be providing technical data to prohibited parties. Both under the ITAR, the EAR, and the OFAC regs will each have their own independent lists, but you should screen all the lists that are appropriate for you. There's a consolidated screening list for that kind of effort, and private third-party software that adds some robustness to that effort. And then you also need to understand the end use. If you have a professor dealing with a foreign technology company to advance something in a particular field of expertise, you need to have a good understanding as to what that technology is going for. And if the particular foreign company has some loose ties to some entities or governments that the United States doesn't view very favorably, you need to approach with caution and address the red flags and do enough vetting to make sure your professor is not directly or indirectly feeding an effort that's contrary to U.S. national security concerns or foreign policy concerns. That's probably one of the most common questions for us as private counsel is, we have a foreign company that would like to fund a research project and a professor's year of research with 2 or 3 PhD students over here in X country. We recognize them as the experts in this field, and we want to be working with the best. And obviously the professor, for prestige purposes, says, hey, I want to do this as well. Let's do this. Depending on that relationship and the dynamic and the content of the research, you may need to pump the brakes on that quickly before any binding contracts get signed and any sensitive information may get transferred inappropriately. You want to understand the content of the technology, the players involved, and the due diligence checks and balances that you should be doing for any kind of foreign recipient. And if this analysis turns out that you need a license, it's okay. That's not a game breaker. A license can be applied for and received in many cases. So, again, to recap, you have a project involving some restricted technologies. You've gone through the exclusions we went through. You convinced yourself it's not published or in the public domain. It's not fundamental research. There's a lot of restrictions on what I can do with this. The ITAR and EAR exemptions don't really apply in this case, so I need a license. That's all right. It's just one more loop in the process for you, one more hoop to jump through. You can, once you understand the involved players, the recipient, whether it's just one or two students with one professor, it's a pretty small-scale transaction. If it's a major, multi-year educational exchange type of setting, understanding all the players and the moving technology is going to be a bigger effort. But once you collect that, you summarize the relevant project, and you put that into the license. This exercise helps you as an export control officer understand where the weak points are going to be, who has to be trained, et cetera. But as you're putting together a license, a lot of that stuff just bubbles right up to the top as you're going through it, because as you're writing it to the government, you're going to be seeing the same weaknesses the government would be seeing as well in terms of compliance and controls. And on my last bullet here, if it's a particular ITAR issue, you may actually have to manufacture with DDTC as a manufacturer of defense articles. It seems a little silly if you're not making any physical defense article, but if you are working with and exporting ITAR-controlled technology, you may trigger that requirement to register with DDTC. And really, it's just that's all it is, registration. You put in your basic corporate or entity information so DDTC is aware that you're in the ITAR world. There are a couple other causes where you may need to send something in to the government to file, and this is kind of a random list, but the common thread is that you're sending something into the government. In the ITAR world, there's a concept called the Technology Assistance Agreement, and if you were on last Tuesday's webinar, you are almost an expert by now. This is a kind of a broad blanket license for exchanges of technology, not physical items, as approved by this TAA, so individual licenses aren't required for every email, et cetera. For example, if there's a high-tech foreign exchange with a foreign university, students working overseas, students working here, U.S. students visiting, foreign students visiting you, et cetera. If it's an ITAR project, the TAA might be an appropriate vehicle for you to pursue. In addition, if you are having trouble figuring out what is the controlling technology here, I can't figure out if this is ITAR controlled, if this is EAR controlled, you could submit the what's known as a commodity jurisdiction request to DDTC for ITAR products. They'll tell you, yes, this is ITAR under USML category blank, or they'll say, we believe this is controlled in the EAR, which is a useful data point, one way or the other. You know what the government says. More specifically, if you want to figure out which ECCN applies, or whether something is EAR 99, that's the catch-all term for anything subject to the EAR but not specifically listed in an ECCN, you can submit something through the CCAT system, the Commodity Classification Automated Tracking System, and that's essentially the same type of process, but on the EAR side, they'll review the package of information, relevant background, and history, and tell you which ECCN applies. And then, despite all these, good compliance efforts, when things go wrong, and we'll get into some enforcement cases when things have gone wrong, you have the voluntary self-disclosure option at your disposal most of the time. There are some disqualifiers, but sometimes when you find your own violation, it makes sense to just voluntarily disclose it. You summarize the facts, what the root cause was, what you did to correct it, etc. The government appreciates the fact that you voluntarily did that and are improving your business operation or educational operation, and will go easier on the fines and penalties, and oftentimes they'll just give you a warning letter or a non-violation letter just based on how severe a particular issue is, and remind you to keep doing good work and improving constantly. Though occasionally the voluntary disclosure will come back with a penalty or a more severe violation, so there are some pros and cons to be evaluated before you go ahead and voluntarily disclose. Generally, though, the answer is that there's more benefit in going with a voluntary disclosure than not. I did mention I wanted to hit the OFAC topic at least briefly for this, just so it's more of an awareness point for you. But the U.S. Treasury's Office of Foreign Asset Controls administers economic sanctions, embargoes, and specially designated nationals. Those are individuals that are prohibited parties, individuals and entities, rather. So with the gearing this to the university compliance setting, there of particular interest may be prohibited or restricted travel. You have professors or students that want to do some kind of exchange in a few of the troublesome type countries like Iran, Cuba, Syria, now North Korea is getting a lot of national headlines. So you want to be very cautious as to what travel is acceptable and what is not. So, for example, if you have been following, or even if you have not been following, the current administration announced a travel ban for all U.S. passports regarding North Korea, which becomes effective in less than a month. Obviously, the tragedy with a U.S. student earlier this year motivated part of that, but you, as an export compliance officer for a university, want to be very aware of that for your students and your faculty. In addition, Cuba is a hot spot, no pun intended, for educational travel and using the educational license exception there for Cuba. It exists, but it's narrow. You want to be very careful that you are cleanly within the scope of a particular general license for Cuba, and these are just some examples. There are some restricted academic exchanges with Iran, though a lot of universities find that general license G for Iran specifically can be very useful in terms of coursework and things like that for Iranian students and those present in Iran. So, like I said, I wasn't going to get too deep into OFAC issues for the university. If there's anything offline, you'll have my email on the last slide, and we can take another look. As I mentioned, things go wrong, and part of this compliance effort is to avoid the enforcement phase of any particular matter. The University of Tennessee Professor Roth case I mentioned at the top in 2009, which, I continue to think is recent, but now is 8 years old, so it's becoming a little more stale. But it is definitely the biggest and most attention-grabbing type enforcement matter in the university setting thus far. More recently, UMass Lowell had something as simple as an EAR 99 item, but it was shipped to or transferred to somebody on the BIS entity list. For those unfamiliar with the BIS entity list, that is a list of more or less prohibited parties where a license is required every time before something gets sent or transferred to that particular entity. BIS will likely deny any license request, but it's not required to deny a license application if the particular scenario and facts warrant an appropriate export to something on the BIS entity list. it can be approved, but the license requirement is strict for those. So UMass Lowell did not follow that process before sending something to the entity. What's interesting here, as opposed to the University of Tennessee case, it was the university that got the penalty, not the professor that arranged for the transfer. So as an employee of your institution, you want to look out for the institution's best interests, and an individual screwing up, whether it was intentional or not, can lead to some significant penalties for the university itself. In this case, it was a $100,000 penalty, and they were not allowed to export for 2 years. So it was that could affect a lot of international programs, et cetera. So a learning opportunity for you guys. Of course, all information on all of these is available online. You can kind of do a case study if you want to get the nitty-gritty details. University of Michigan, as I almost didn't put this in as a Michigan alum, but a research fellow at U of M was prosecuted for an export of a medical device to Iran. Nothing of particular national security sensitivity, but because it is Iran, it gets a lot of attention. This is a medical product that would have been easily licensed under the medical license or under the medical products controls of Iran and the exceptions there, but because this particular fellow went out of sequence, it was sent to Iran without the license first, and this one was particularly enforced by OFAC, who runs the Iran sanctions. And then a more recent one in 2015, actually a naturalized U.S. citizen department chair in the physics group at Temple was charged with knowingly transferring semiconductor technology to China, ended up settling a penalty with that one, and I'm not sure why my last bullet didn't show up on what the outcome was there, but there were some pretty damning pieces of evidence where this particular department chair was skirting the export rules on purpose to get some of this technology to China from his private sector experience, and he had only joined the particular university pretty recently as this was going on. So in my last couple of slides here, I'm going to throw in a little bit of a bonus issue that applies to universities and non-universities here in this dealing with non-U.S. person folks in your facility or in your enterprise, in your company, et cetera. So there is an Immigration and Nationality Act. This is a federal statute, and the citation is there. This prevents and prohibits discrimination based on national origin, citizenship, and immigration status with respect to hiring, firing, and recruiting. In addition, there's controls on unfair documentary and retaliation, but really for purposes of this slide, you have some kind of prohibited discrimination based on these qualities. So we've discussed this whole time about being careful about preventing unauthorized exports, and now I'm introducing this concept of you want to avoid, unlawful discrimination. So you may feel like you're trapped here between a rock and a hard place, and I just like this photo, so I throw it in when I can. But it is an issue where there's an overlap between these discriminatory protections and obviously export compliance and being diligent about understanding who your recipients are. So while a colleague of mine have done a full hour-and-a-half presentation on this topic, I'm squeezing it into 3 slides, so please keep in mind that this is a very abridged version, but as an example of where you find some compromise in between the rock and the hard place here are some guidance letters from the government that address this issue specifically, and while they don't give industry the full, complete answer. They do give you some guideposts and tidbits where you can rely on something pretty comfortably. And they've pretty much blessed this question as okay, and by okay I mean non-discriminatory. So while potentially hiring a foreign person, you are allowed to ask, will you now or in the future require sponsorship for employment visa status? And that strikes a delicate balance between gaining information about a potential employee but not discriminating or even adding to the perception of discrimination for the applicant. So keep that in mind. Straying too much from this question in any direction can get you in trouble. So if you're going to rely very heavily on this for a particular hire, give a call to counsel, Immigration and Employment Counsel, along with export control. Issues should be vetted in that kind of scenario. But that was just a little bonus issue to keep you chewing on this topic as we wrap up the presentation, and we'll open it up to the questions.
Thanks, Alfredo, for a great yet another great presentation. To remind folks, I know we had a couple questions come in over the written queue, which we will get to in a moment. If you'd like to ask a question over the audio lines, you can press *1 and then record your name, and we'll get you into the queue. But for now, we can start with the written questions that have come in. And the first one, Alfredo, comes from Kathy Day, who asks, and this was entered at the beginning of your presentation, when you were talking about branch offices of U.S. corporations, did you mean foreign subsidiaries of a U.S. company or just branches within the U.S.?
For that particular definition, I'll bring the slide back up here. So in this particular scenario, this branch offices of U.S. corporations are considered U.S. persons. So this is not a foreign subsidiary, because that would be a standalone entity, but a foreign branch of a U.S. company would still be considered a U.S. person. This is common on physical borders, like if you have a U.S. branch on the other side of the U.S.-Canada port of entry that isn't a Canadian incorporated business, that kind of branch that's not a subsidiary would be a U.S. person for purposes of export analysis here.
Okay, the next question in the written queue is a little bit more specific. For deemed export of technology to a foreign national employee who works full-time in the U.S. and is covered with U.S. benefits, what address is entered into the DSP-5 Block 14 and the BIS 748P Block 18? This particular individual lives in the U.S. full-time.
Well, if you'd want to use if it calls for the business address, even if it's in the United States, that's what it calls for, and I forget what these particular blocks on the ITAR and EAR forms call for at the moment. But if it asks for the home address, the home address is the real residence, even if that's in the United States. The rest of the application should include enough information that it's a foreign person resident in the United States, and that should be enough.
Operator, have we had any questions come in over the audio queue?
I show no questions at this time.
Great, thanks. So the next question in the written queue is, if we ship to a domestic company, how do we know that the person receiving the information or commodities is not a foreigner?
Good question, and generally speaking, if you're shipping to a domestic company, you're not exporting by sending it to that entity. You can bake in some contractual protections, such as in your purchase order process, bake in some kind of certification from your buyer or end user that they will comply with applicable U.S. export laws and regulations. And if you specifically list the ECCN or ITAR category involved, that helps, your it helps your file, so to speak. And I don't want to make it sound like it's all about protecting your file, but if you show your business process is to highlight for your customer that, hey, this is subject to export controls, and you're certifying to us that you are doing what you need to on your end, even though this is a U.S. to U.S. transaction, should be enough, as long as there's no reason to know that everyone in this particular facility is a non-U.S. person that would require a license for the particular product you're exporting.
And the last question we have is regarding the penalties for the Michigan and Temple University examples that you brought up.
Yep. You know what? I don't have those in front of me. If you Google some of these keywords from the slide here, at number 22, I'm sure you can get the summary. I'm happy to dig it up after the presentation and shoot it over to you, Deanna, if you want to shoot me an email.
And operator, we'll do another check of the audio queue.
I show no questions.
Well, thanks again to everyone. Thank you again, Alfredo, for sharing your expertise. Oh, actually, we just had one other question pop up, which is a follow-up question to the deemed exports regarding the foreign national employee. So the particular block that they mentioned, block 14 of the DSP-5, is the foreign end user. And since the end-use country is a foreign country, you cannot add a U.S. address.
I understand where your question is coming from now. I would want to check the DSP-5 form again. I haven't looked at it in months. It's a little outside of the scope of my legal advice type practice, but I'm happy to take a look at it with you if you want to give me a call in the next few days, Joanne, and we'll try to find the right answer for you.
Great. Thanks, Alfredo. Appreciate that. And if there are any other questions that didn't get asked during today's presentation, again, you can see on the screen that's up now, the slide that's up now. You can call Alfredo or feel free to shoot him an email. And thanks again for everyone for your time today, and we look forward to talking to you on Tuesday on our presentation on export controls at trade shows. So have a good afternoon. Thank you again.
Thank you. This concludes today's conference. You may disconnect at this time.